In this video, we'll discuss crimes against person, crimes against liberty, and we will discuss it in the context of teaching complex, special complex crimes. This is how it looks like in your list of syllabus list, right? We will discuss it so that we can explain complex crimes and special complex crimes. Let's get right through it. Okay. So we're talking about crimes against person and crimes against liberty. All right. We'll take note this provision is very specific on liberty, and the syllabus will not include personal security, but yeah, we'll discuss that more a bit. Now take note, when you the revised penal code talks about crimes against persons in the context of killing, hurting, and because of anti-rape law of 1997, raping. All right. So when it's crimes against person, it's killing, hurting, and raping. Now, when a spouse kills an ascendant or descendant, that's reclusion perpetua to death. That is your parricide. Take note, the revised penal code will also show that abortion, an intentional or an unintentional abortion, or an abortion committed by the midwife is likewise penalized under crimes against person because of the killing of an unborn child. Now 2476 talks about when you kill your spouse, it can be either the man or the woman who is caught performing a sexual act with another person other than the spouse. There's a penalty of destierro. And then killing somebody without the qualifying circumstances, it will be called homicide. The penalty is reclusion temporal. But if the killing is committed with qualifying circumstances, we look at those listed in Article 248, it will become murder. The penalty is reclusion temporal maximum to death. If you assist a person commit himself by assisting a suicide, and it causes the death of the person, the penalty is reclusion temporal. It's like homicide when you assist and it causes his death. If you assist and does not cause the death of the person, the penalty is arresto mayor medium to maximum. When you agree to kill each other, there's a duel. This likewise is penalized, defined and penalized under the revised penal code. And there's a provision on tumultuous affray when if somebody dies and we cannot identify who killed, penalty is prisión mayor on those who inflicted serious physical injuries. And if there was a rumble or tumultuous affray and only injuries were inflicted, the degree lower for the physical injuries reflected will be imposed on that person who caused that injury. Now we move further. When you talk about hurting, all right, hurting, we're talking about mutilation. If you mutilate a sexual organ, the penalty is reclusion temporal to reclusion perpetua. And if you mutilate not a sexual organ, maybe an ear, a finger, when you try to hurt somebody, then that is the penalty, prisión mayor, medium to maximum. Under the classification of crime against person is hurting or causing physical injuries. What is the crime of physical injuries? When you wound, beat, assault, to hurt somebody, and the effect is you beat, you assault, and or cause the incapacity of that person to work. Now physical injuries can be, there are three types: serious, less serious, and slight. Now if you look at 264, if you administer an injurious substance without intent to kill, all right, there's still a penalty. It's still physical injuries depending on the effect. If you just look at 264, but the point is, this word here, without intent to kill, in administering a injurious substance, gives you an idea of the difference between hurting and killing. We'll do that. So let's have a discussion on that. Without intent to kill, because hurting some, if you want to if you want to kill somebody, general rule is there's going to be a hurting before the killing happen or before death happens as a consequence. So let's discuss this a little bit. All right. So person A says, "I will kill you." So it's very clear. The intention is I will kill, but the person stabs the victim, but because of aim, poor aim, no, stab only the finger. So what is it? It will be an attempt to kill because the intent to kill is very clear. So it's an attempt to kill. This is different from I will kill you. The attempt to kill is established, but the person was able to stab the victim in the vital part of the body, and there's a testimony from a medical expert saying that had it not been for the immediate medication, then the person would have died, right? And the person survives. That is your frustrated killing, right? Because there's an attempt to kill. It's established here. There's an intent to kill. There was an injury in the vital part or organ that would have caused the death of that person had it not been for timely medical intervention. That is a frustrated killing. All right, no intention. There's no saying I will kill you, but the person stabs. Very, very strong stab, no? Wow, there's a swoosh. And the finger was hit. So if we are not able to establish the intent to kill, that will only be consummated physical injuries because of the wounding, beating, maybe even a mutilation. All right, but that is, without proving the intent to kill, it's going to be a consummated physical injuries. All right, let's do it again. No intention. It's not clear if there's an intention to kill. There was a stab multiple times in the vital part of the body. So what is that? What do you think? Well, even if there's no expressed intention of killing, the multiple stabs in the vital part of the body will show that there is an intent to kill. All right, so you go back. So it's like saying their intent to kill is proven. Now look, was it an attempt? Meaning, the killing just began, but a vital portion was not hit, or stabbed multiple times and the person was injured in such a way that had it not been for the timely medical intervention, death could have ensued. Though this is not part of the syllabus given by Justice Leonen, I should say, if you look at Article 6 of the Revised Penal Code, what is an attempted crime? Well, there's an attempt when the offender commences the commission of the felony. I will stab you, start stabbing, commences the commission of the felony directly by overt acts of the stabbing, but does not perform the all acts of execution which should produce the felony. I will kill you, started, that's the intention, and then the offender commences the commission of the felony directly by overt acts of stabbing, but does not perform all acts of execution which should produce the felony. How could he produce the felony of killing that person when only the finger was hit? So that is your attempted felony. All right, now contrast this. Let's again look at Article 6. It is frustrated when the offender performs all acts of execution which would produce the felony as a consequence. All right, so the accused, the offender performs acts of execution. He said, okay, there's an intention, I will kill you, stabs the person. In fact, hits the person in the vital part of the body which could have led to death. So has completed all acts of execution which should produce the death or the felony, but nonetheless, it is not produced by reason of causes independent of the will of the perpetrator. And that cause independent of the will of the perpetrator is your medical intervention. That will become a frustrated crime. Like I said, Article 6 is not discussed in your syllabus, but nonetheless, we discussed it. All right, now let's go to this one, to Anti-Rape Law, 1997. Oh yeah, before we go there, take note. Here's another example. Uh, there's a person carrying a shotgun, aims at the person and goes boom. Imagine the shotgun sounds so loud and so powerful that you think somebody will die. No? That's the idea of a shotgun. But if the intention of killing is not seen, even if a powerful gun was used and there was only one shot, well, you cannot say, you'll have to say that, okay, since it's just one shot, we cannot see that there was intent to kill. And that will be only a consummated physical injuries, even if the person was hit. Now, even if the shotgun was fired, but if the shotgun was fired so many times, even if there was no "I will kill you," you could say that, well, since it was shot many times, the intention is shown that there is an intent to kill, and this will be either an attempt or frustrated homicide. And if the person dies, well, it's consummated. All right, so that's the idea. Look at the intent first, and look if the acts of execution were performed. All right. Now let's go to Anti-Rape Law of 1997. Like I said, in the Revised Penal Code, rape was not part of crime against person not until 1997. All right. Now, in the Revised Penal Code before 1997, we know that rape is all about carnal knowledge, meaning the penis touching the labia, and the penalty for under circumstances when there is no consent. That's the idea of carnal knowledge under the Revised Penal Code. And the penalty is reclusion perpetua. Now, this Anti-Rape Law of 1997 included another form of rape, which is sexual assault. And that is when a finger or an object is inserted in the anal or oral orifices of that person. Both are rape, but the carnal knowledge rape, the penalty is reclusion perpetua, but if death happens, the penalty will be death. No? If there is a rape of the sexual assault kind of rape, the person dies, the penalty will be reclusion perpetua. Now, if there is an attempt to rape and death ensues, then the penalty will be reclusion perpetua. So what am I talking about? We're talking about this should be this should start the discussion on special complex crimes and special complex crimes. We'll go to that in a bit, no? But the point is this: we are discussing crimes against persons and how they are, and later they will intersect, no? So let's talk about this one: crimes against liberty. Take note, in the Revised Penal Code, there's a difference between crimes against liberty and crimes against liberty and security. All right, so we'll talk about liberty. What is a crime against liberty? When there is a detention, unjust or unreasonable detention. Take note, there's a serious illegal detention and a slight illegal detention. That's a penalty, reclusion perpetua to death. This one is reclusion temporal. What's the difference? Well, the detention lasts more than 5 days. Serious illegal detention. Below 5 days, slight illegal. Public. If the victim is a public authority, and if you detain and there are threats or you injure that person while on the occasion of the detention, that will be serious illegal detention. Or if the victim is a minor, female, or a public officer, that will be serious illegal detention. Take note of the proper the penalties. All right. Reclusion perpetua to death. This one is reclusion temporal. All right. So talking about liberty, we talk about detention, arrest. So if a private person arrests or detain another person without legal grounds with the purpose to deliver to public authority, that is a crime. All right. In 269, it's called unlawful arrest. Lawful arrest. So again, crimes against liberty is about detaining. All right. So there's detention. But take note, in Article 270 and 271, there is still a crime on against liberty if you refuse to return a minor, no? So refuse to return a minor, it's a or if you induce that minor to abandon the home, that's your crime against liberty. And well, and 272, 274, and 273, the law talks about slavery. All right, so the law says when the purpose is to enslave, all right, you detain a person with the purpose of enslaving, that's slavery. Or when there is a compulsion to pay the debt, all right, you detain as a compulsion to pay the debt. Or 273, when a minor is forced to serve to pay a debt. Take note, it's called exploitation of child labor. But the revised penal code says, 273, exploitation of child labor means you allow the minor to do service in order to pay a debt. It's very close to this one, the compulsion to pay a debt. All right, like I said, we will try to intersect these crimes, and I think this is what will happen in the bar exam. They will, the examiner may most likely ask questions regarding crimes against person and liberty, so that this idea of complex and special complex crime can be tested. So let's go to that. Okay, so here we go. So, say for example, A wanted to rape B. The intent is to rape. Of course, A cannot do that, in a public place. A will have to detain that person for order to rape. So if you look at it, there are two crimes, no? The detaining and the raping. But if you look at Article 48 on complex crime says, when one offense is a necessary means to commit the other, that's complex crime proper, the penalty for the most serious crime is imposed in the maximum period. So, if the intent is to rape, you have to prove that the intent is to rape, or you have to find out the intent. But there was a detention. No, one offense is a necessary means to commit the other. So it's just one offense because the other is a necessary means. So what you do, look for the most serious crime and impose it in the maximum period. Some Supreme Court decisions will say absorb, but if you look at the revised penal code, you don't see any word absorb. No, it's all in jurisprudence. So this is the legal basis of that quote unquote absorb. All right, now let's do this. Now, the second idea. Now, if the intent was to detain, maybe A detained the girl with the intention of ransom, all right, and then A thought, whoa, let's go do another crime, no? All right, but was rape, but the person really wanted to detain, or the person was detained, the person was detained, and then you tie the hands, and then put something in the mouth, but dies on the occasion. So look, there's a detention, the detaining, and the killing, or the detaining and the raping. They are different crimes. This one is detaining, crimes against liberty. The raping is crimes against person. The killing is crimes against person. But because of 7659, it says if a person is detained but was raped or dies on the occasion of the detention, that is a complex crime. So how many crimes will be seen? Just one crime. The penalty shall be death. Also in 7659, when for example, and we'll talk about property, crimes against property. If a person wants to rob, and we know that robbing means violence against a person, or violence on things or persons, or intimidation on person. All right. So if there's an intent to rob, but then the person dies, or a person barges into the house of another, there's force upon things on the door, break down the house, tied up maybe the persons in the house, and then there was a rape. There's a crime against property, the robbery. There's a crime against person, the rape or the dying. But because of RA 7659, it becomes a special complex crime. The penalty is reclusion perpetua to death if there is a robbery, but on the occasion somebody was raped or somebody dies. That makes it a special complex crime. That is why when you define special complex crime, there's a part that says there's part of the definition that says it is specifically defined by the law. All right. Now, another discussion on Article 48. X aimed to shoot B. Oops. All right. So A fired at B, but A missed B and hit A. So how many crimes are committed? Really, there are two. The attempt on B, wanted to shoot B, fired at B, but did not hit B. There's another crime of hitting A. So there are two crimes. And we know that this is a crime even if B was not hit, because Article 4 of the Revised Penal Code says, well, when you're committing a felony, you shall be liable for the felony committed, although the wrongful act was not intended. So there are two crimes: attempt on B and the hitting of A. Now, because of Article 48 again, which says when a single act causes two or more grave or less grave, that's just one offense, all right? But the penalty for the most serious crime shall be imposed in the maximum period. This is also in Article 48, but it is called the compound crime. Compound crime. So that's it. That's our discussion on on crimes against persons and liberty, and we discuss it in the context of complex crimes and special complex crimes.